Start. Tested on the touchstone of the aforesaid principles, we have no trace of doubt that the finding returned by the family judge, which has been given the stamp of approval by the High Court relating to mental cruelty, cannot be said to be in ignorance of material evidence or exclusion of pertaining materials or based on perverse reasoning. In our view, the conclusion on that score clearly rests on proper appreciation of facts and hence we concur with the same para. Presently, we shall advert to the finding recorded by the learned family judge and the High Court relating to desertion by his wife, as the factual matrix would reveal, both the courts have proceeded on the base that the wife had not endeavored to reunite herself with the husband, and there had long lapse of time since they had lived together as husband and wife. On the aforesaid foundation, the conclusion has been drawn that there is an animus desidendi on the part of the wife. Stop. To test the tenability of the said conclusion, we have perused the petition for divorce, from which it is evident that there is no pleading with regard to desertion. It needs no special emphasis to state that a specific case for desertion has to be pleaded. It is also interesting to note that the petition was not filed seeking divorce on the ground of desertion, but singularly on cruelty. In the absence of a prayer in that regard, we are constrained to hold that the conclusion arrived at as regards desertion by the learned family judge, which has been concurred with by the High Court, is absolutely erroneous, and accordingly, we overturn the same para. The High Court opined that when the efforts were made to get the primary evidence and it could not be obtained, the secondary evidence could be adduced, and that would be admissible under sections 65 and 17 of the Evidence Act. Be it noted, the English translation of the said letter was marked as Exhibit R9, which indicated that the wife had clearly stated that she had spoken ill of her mother-in-law and others, and had expressed her desire to seek divorce as she could not stay any longer in the matrimonial home. Stop. It was observed by the bench that the conduct of the wife clearly established desertion, and her behavioral pattern exhibited mental cruelty meted out to the husband. Stop.